Attorney's Office on item number 2? Okay. Ready for that?
Yeah.
All right. We'll go to item number 2. Please announce item number 2.
And item number 2 is a resolution, Perry Park Smith, and a report from the Chief Legislative Analyst relative to the city's position to oppose SB 1168, which would allow the LA County Superior Court to impanel an additional grand jury managed by the city attorney to investigate misdemeanors.
Can I ask Mr. Miller up there too?
Sure.
Okay. Jerry Miller.
Is Jerry here?
Yeah, he's right here.
Okay, I didn't see him.
Yeah.
Go ahead.
Good afternoon, William Carter, Chief Deputy on behalf of the City Attorney's Office. With me to my right is Pete Echeverria, Chief of the Civil Branch, and also Earl Thomas, Chief of our Criminal Branch.
Okay. All right, this is a
And if
bill
I'm
in
sorry.
the state legislature that is being supported or sponsored by the City Attorney's Office of the City of Los Angeles, correct?
Yes.
Okay.
On his behalf as the elected city attorney.
Yes, as the elected city attorney.
And if I may, Councilman Cardenas, today, before the hearing, we submitted a one-page cover letter with 2 attachments. One is an attached letter dated May 28th of 2010, addressed to Councilwoman Perry and Councilmember Parks in response to a letter we received from them on May 26th. We've also attached a letter signed by Sheriff Lee Baca in support of this bill, SB 1168.
Okay. But the letter from Ms. Perry and Mr. Parks is not attached,
So-
just the response.
Correct, yes. I assume that members of the committee may have had that. I apologize if you needed or wanted that.
Thank you. All right. Okay, so can you give us an overview of what the bill entails? And then I'll have some subsequent questions regarding the bill. Go ahead.
Yes, thank you. The Senate Bill 1168, the author is Senator Gil Cedillo. My boss, Carmen Tutanich, as the elected city attorney, is sponsoring that bill. In a nutshell, what it does is it grants any cities within the County of Los Angeles having a population of 3 million or more, which is very specific to the City of Los Angeles, has the authority, does not mandate, but has the authority to initiate and panel a grand jury. The grand jury would be made up of the same members as are currently made up of jurors that review criminal matters in the City of Los Angeles. Those grand jurors would be allowed to, that grand jury would be allowed to issue subpoenas for documents and records, and also to hear testimony from witnesses under oath, similar to those grand juries that are operating throughout the state and this nation. Would be confidential. The grand jury could not issue indictments. In other words, we would have to file those cases under a complaint. The grand jury power would be limited to certain types of white-collar or sophisticated misdemeanor crimes, consumer, environmental, frauds, corruption, workplace safety, those types of sophisticated cases that are different and apart from the traditional street crimes that other types of prosecutors do. It also, more importantly, has a sunset provision that this power would expire on January 1st of 2014, or essentially at the end of Mr. Tutanich's first term.
Well, actually, the terms in the City of Los Angeles end in the middle of the year, June 30th. So it would be shy of 6 months of his current term expiring. But should this bill actually get past the legislature and get signed by the governor, it would take effect on January 1st, 2011, correct? So basically, if it took place right now, the sunset allows it to exist for 3 years,
Correct.
3 full years.
That's my understanding.
Go ahead.
The bill, as initially drafted, was very general. The way it was drafted, it covered all misdemeanors. However, when it went through the first Senate committee, Public Safety Committee, members of Speaker Steinberg's staff and others approached Senator Cedillo in our office and asked us to be more specific, to focus on and specify those more sophisticated violations, which they did, and that's why the verbiage looks the way it is. We initially had it just for misdemeanors, but the language as it now exists in terms of environmental, consumer, and other types of more sophisticated crimes, that was language that was amended by Speaker Steinberg and others in the Senate. We believe that this particular authority would give us, one, a more cost-efficient way to investigate more sophisticated violations, as we set forth in our letter in response to Councilmember Perry and Parks's letter. This is a force multiplier. Currently, the District Attorney's Office, they reject or decline to file certain sophisticated white-collar cases that in other counties would be seen as felonies. But given the size and the number of cases that we have in Los Angeles County, they get kicked down to the City Attorney's Office. And we have to file cases that elsewhere would be a felony. We go against some of the largest and most sophisticated companies, healthcare, banks, environmental companies, and we don't have the tools, one, to investigate them and to properly prosecute them. I come from a federal law enforcement background. I used the grand jury probably 500 times in terms of investigating and indicting cases. There's no other tool that is more cost-effective and more controlled than a grand jury. In addition to be able to obtain documents in a timely and cost-effective way, there's also an ability by people to oversee what you're doing. We will properly manage this to make sure that there are no abuses. There were some concerns that perhaps this grand jury authority would be used by the City Attorney's Office to investigate and prosecute people within the city family. One, we will not do that, and we cannot do that because we are governed as lawyers. My boss, who is a lawyer, that's a predicate to be a city attorney, is governed, as well as all of us are governed by the state rules of professional responsibility and conduct. We cannot investigate nor prosecute our own clients. So we will
Now,
not
can
be
you
able-
give me an example of who your clients are in what you just explained?
Well, at a minimum, we have the mayor, we have the city council, we have various public
City controller?
controller, general managers. We have sometimes city employees and departments. So if, for example, and we've had this situation come up since we've been here, we've had situations where we've learned information that perhaps city employees are engaged in behavior that would be considered in violation of criminal law. We don't handle that. That gets referred out to another agency to look at. That is one way. If, for example, we were to learn something in our position as city attorneys, as your lawyer, or any other city family lawyer, if we were to learn something that we learned in confidence, we could not do anything with that information. We could not say, aha, you told me something that's a violation, now I'm going to go tell somebody else. You may recall former city attorney Ira Reiner was censored by the state bar, which is a very high sanction, for obtaining information in a confidential manner and then turning that information over to someone else. That was found to be improper by the state bar, and I can tell you that none of us all of us understand that, and none of us in the city attorney's office want to be put in that position. Our focus, rather, as we put in our papers, for a few weeks ago, we went after Ralph's Supermarkets for engaging in short wait, and we were able to prosecute violations involving 11 stores. If, for example, we had another situation like that, and someone said, we have violations, we have to send inspectors out to each one of those stores, and we have to gather information. It takes a long time. If, for example, we get that information, we then draft a grand jury subpoena to the target company and say, we understand you're engaged in this activity. We want to see all the weights and measures relating to this type of activity. That information comes in a timely fashion. You put a 10-day or 2-week limit on it. You bring in the custodian of records for that company and say, I want you to explain to me what these records mean. You can build a case, not with 10 stores, maybe with 100 stores, and maybe with a subsidiary. At that point, you've built the case, and then the companies say, you know what, we need to get this thing over with. They come in, they start to negotiate with you, not only compliance, but also potential resolution of that criminal case, so you don't have to file the case. Right now, what we have to do is gather evidence, then we file the criminal case, then we have to issue subpoenas, dukes, and take-em, and maybe we get documents from that. That is no way.
Why is there maybe you get documents? Because the general public assumes that if you file a case and that case is actually going forward, that when you ask for documents, that they're required to provide documents, and a judge actually would determine if somebody questions whether you had the right to those documents, and the judge would say, turn over those documents. Why do you say maybe?
Because once you file the criminal case, you're on a timeline. You have speedy trial rules. You may be under a 45-day clock. Maybe if you get an extension, it's longer. You issue that subpoena, dukes, and take-em, and you can ask the court to shorten it. Give it to me. Maybe the trial's in 45 days. Can I have the records in 20 days? Judge doesn't have to give it to you. He could say, nope, that SDT should be turned over on the day of trial. So you may not get one, or they could file a motion to quash. They could say, you've asked for too many documents. Then you end up litigating your subpoena when you're trying to get ready for trial. So, one, you may not get all the documents you think you're entitled to, and two, you may not get them in a timely fashion. You may actually get them on the eve or the day of trial. Now, if you can avoid all that uncertainty, you do it up front. Issue your subpoena, and then you get the documents, you have a chance to look at them, and you actually might be wrong. You might say, you know what, I don't think they're doing this type of violation. Maybe they're doing it a different way. So I charge my case a different way, and I have it before trial. I may not even have to file the case. The corporation may come in and say, you got me, it's over, let's resolve this. The other thing you have to keep in mind is these cases, which would be considered felony in any other county, but when you have a felony, you have a 3-year statute of limitations. The DA has 3 years to put this case together. When you're a misdemeanor shop like us, we have 1 year. So we have to put this case together in a shorter time period, fewer resources. That's why the grand jury is important. Now, we're not going to be using this grand jury every day. It's not like we're going to be cranking out subpoenas every day. We're going to use this in a judicious manner. That's why I have Chief Earl Thomas here, if necessary, to give you an idea of the types of things we're doing. But I think it is a force multiplier to allow us to handle those big cases that otherwise wouldn't get done.
Yeah, but one of the first things you just said, that when you were working on federal cases, that you convened the grand jury how many times?
I was probably in a grand jury at least 500 times.
500 times?
Yes.
That's not a lot.
Well, everything is indicted under federal law. There's no federal prosecutors don't do prelims. In other words, under federal law, everything is indicted by grand jury. Not here, not on the state side. We file complaints.
So you've been in the city attorney's office for a long time. You understand this potential tool that is going through the legislature that might be given to the city of Los Angeles, specifically to the city attorney's office, to convene a grand jury. Can you at least give me a ballpark of a low side and a high side of how many grand juries may be convened in the first 12 months through the year of 2011, should this tool become available?
It'll be one grand jury. In terms of my experience, every case that goes, every federal case has to go before a grand jury. And you could do 10 in one day. But it's like bank robberies, treasury check, other things. Everyone has to go get a return bill. It's called a true bill indictment. But the grand juries are years, 1 year. Now, if we get the authority, we can make them 6-month terms or 1 month or 1 year terms. You have, typically it's 23 people. You have 23 members of a grand jury. They sit for 1 year. You would have alternates, so you might get up to 25. You would have to impanel them from the current system that they have in the county. The jurors that sit on our criminal trials, misdemeanor, are drawn from the entire county. You have to get a panel of people that are willing to sit for a year. They do that across the street in the federal courthouse. They do it down the street in the county courthouse. You get those members. They meet once a week. So they meet 52 times for 1 year. And then you would bring whatever cases in you're working on. And given the workload, they might maybe look at 1 or 2 cases each week.
Okay. Now, that being the case, my next question is, what is the city attorney's office estimation of cost? Because according to the state legislature, they estimated that it would be at least $600,000, or how much did they estimate, and what's the estimate here locally?
That was the estimate that we understood. $600,000 would be the top end. If we had a grand jury every week for a year, that's what we estimated, assuming we had to pay other kinds of costs, copying costs, travel costs, other types of incidentals. We don't think it's going to cost that much. That was the top end cost, $600,000, and that was based on a county estimate, which was a little over $1 million, $1.7 million, somewhere in that range. That was what their grand juries cost. We're not looking at that kind of number. That was the number that we discussed with the state senate.
Okay, so that's highest case scenario, should you
Yes.
have this tool.
Yes.
Okay. Now, can you give us some more examples of what kind of cases that the city attorney's office would focus on, should this be available to you?
Well, currently, we are looking at mortgage fraud. We have a number of banks and others that are engaged in inflating incomes, which is a fraud, which is very difficult to investigate if you don't have subpoena authority. You basically end up knocking on doors, going to victims, attempting to get information from them. You may not get the full package, but if you get a grand jury subpoena, not only from the target, but also the other companies that may be friendly but don't want to turn their documents over for a number of reasons. Mortgage fraud. We have slumlord and housing fraud, where we have a lot of people that are victimized by slumlords. Lead abatement, asbestos abatement. We also handle environmental and consumer. Ralph's is a good example of that. Some of you may have some of these Ralphs in your districts where they short weight constituents. My background is in environmental and workplace safety. We handle a number of air pollution violations, which are misdemeanors. People that are selling or distributing or releasing air pollutants. We also have hazardous waste cases, hazmat cases, which are traditionally misdemeanors. People are hauling, transporting hazardous materials, particularly from the port. They don't have placards. They don't have proper shipping papers. We have other types of consumer cases, lead bottles, lead in candy, those cases that just fall off from the DA's office. They don't do them. And there's this strata of cases that are against very large companies that we have to prosecute with one arm tied behind our back. And that's what we're looking at. We're not looking at street crime. We're not looking at other types of violations that traditionally we can just file a complaint on. That's why Speaker Steinberg's office asked us to agree to that amendment to make it more of a white-collar, consumer-friendly. There's also workplace safety. One of the types of cases I prosecuted when I was in the district attorney's office included people that were killed or seriously injured on the job. You have a lot of labor code violations which result in serious bodily injury or death. and we need to get the records as to why those people were allowed to operate machinery or to go down into trenches without proper shoring. And in order to get that documentation, we need a subpoena. These companies won't turn it over. They won't turn it over until after we file. And then once we file, we have to issue those SDTs. And then maybe we get it. And what happens is, we'll file the case. We'll file the case based on a witness who says, I saw so-and-so do that. It's always nicer to have documentation to back that person up, so you don't get into a protracted criminal case where it's his word against this other person's word. Because when you're trying a white-collar case, a lot of times the jurors see someone on the witness stand that at the time of trial is presented as a pillar of the community, and it's very difficult to, one, convince people that it was a crime, but also that that person was involved in it. But if you've got the documentations, the emails, and the phone records that say, this guy made the phone call on that date, and we connect him to the crime, that's what we need the grand jury for.
Yeah, thank you. Thank you very much, Mr. Chair. I appreciate the time. And once I'm done putting some of my comments on the record, I hope that you will let the Chief Legislative Analyst make their report. I was contacted by a reporter from the Los Angeles Times. His name is Patrick McGreevy, probably almost a month ago, and that is the first I heard of SB 1168, because he wanted to know what we thought of it down here. And so you can imagine my surprise that we hadn't been informed by our own city family that there was a bill and it had already been introduced. My concern is that there is no analysis, and that it was not done by the Chief Legislative Analyst or the Chief Administrative Office as it pertains to the actual costs associated with this proposal and how that relates to our city budget. An analysis of what this bill would mean. Does it represent an expansion of city attorney authority? And if that is best addressed through the charter amendment process. Does the manner in which the bills proposed challenge limitations for legislation established in the charter, and the role of the City Council in support or in opposition to the legislation, and whether the manner in which this bill was proposed is consistent with the city charter? Now, I believe our clerk may have passed out to you each one of the analyses of SB 1168 on file. And if not, I'd like to ask her to do that. In addition to that, there are photocopies there of a letter that was sent to State Senator Gil Cedillo, signed by myself and Mr. Parks, dated May 26th, and then the same copy, a similar copy of the letter sent to Mr. Tutanich. And we did receive his response under the, we had a holiday weekend, so they put it under the door Friday evening, but we happened to, Friday about 4 o'clock, but we were still there. So you'll see in each analysis, and I think there are 5 there on SB 1168, and that is the state legislative analysis on file that states the origin of the bill is the city attorney's office, in other words, a city agency. My primary issue with the bill as proposed is that none of the analysis that I referenced above has been done. And I believe that as an elected official for the City of Los Angeles, that this merits discussion, and the City Council should take a position on the proposed legislation. In digging a little deeper, and we'll have the CLA's analysis, I also contacted Erwin Cherminsky, who played a key role in the charter amendment process in 1999, which was placed before and approved by the voters, and he is traveling, but he gave me an opinion. I think it's interesting to note for the record, and if you don't mind, I'd like to take a second just to put it here on the record. He said, my opinion for what it's worth. I believe the city attorney may, as an individual advocate, advocate legislation in Sacramento. I think that the charter and the administrative code are clear that only the council can take an official position on behalf of the City of Los Angeles. If the city attorney were to purport to be representing Los Angeles, it would clearly violate these provisions. But nothing in the charter or the administrative code precludes the mayor or the city attorney or the controller or a member of council from, as an individual, advocating legislation. I think that there would be serious First Amendment problems with saying that a government official could not, in an individual capacity, endorse legislation. I think that the California legislature has legal authority to adopt SB 1168. The charter and city ordinances are obviously subordinate to state laws. I cannot think of anything that would make SB 1168 unconstitutional. And one question I'll ask the CLA in a minute is about the fact that we are a charter city and what that means. But in his third paragraph, he says, I think that SB 1168 is misguided, and that it would be far more desirable to have such authority considered by a charter amendment. Section 217, subsection B of the charter specifies who has subpoena power within city government. It does not expressly mention the city attorney, nor do the charter provisions concerning the city attorney grant such authority. This was obviously a deliberate choice. The charter easily could have granted such authority. And then he says, paren, I'm very familiar with the provisions of the charter concerning the city attorney. They originated with the elected commission and arose from lengthy discussions that I had with then City Attorney Jim Hahn and Tim McCosker. At no time was subpoena authority for the city attorney requested, end paren. SB 1168 essentially amends Charter Section 217, subsection B by state law. There is no reason for the state to override a charter provision here. SB 1168 is solely directed at Los Angeles and exists solely to confer authority in Los Angeles that the charter does not provide. Thus, while it is constitutional for the state to do this, I think it is inappropriate and misguided. And he said that he's willing to put that in on a formal communication as part of the official record. So when you're ready, Mr. Chair, I'd like to put some questions on the record for the Chief Legislative Analyst. Okay. Yeah, I can wait.
Yes.
We'll go to Councilmember Zhang.
Fine.
The grand jury has a civil and a criminal section. A criminal section, grand jury, civil section. There's two that are already impaneled.
The county does, yes.
The county. Would this then, or could this fall under the civil part of the grand jury and not establish a new grand jury with additional costs?
No,
Since they're already impaneled?
this will be a separate grand jury.
I understand that. I'm trying to see if there's an option to incorporate this process with the existing civil grand jury from the court.
I don't believe so. I mean, well, you've got to keep the civil and the criminal separate.
Well, they do have the criminal and they have the civil.
Two separate grand juries.
And I've been before the civil a couple of times. Then all nice people devote their time. The cost involved would be reimbursed from the city to the county for that particular grand jury, correct?
For this one under SB 1168, yes.
And for the cost of this, would that be an additional appropriation from the city, or would that come out of the city attorney's existing operating expense?
Comes out of the existing city attorney's budget.
And the cuts to the city attorney's office, there's already been discussion about a cut in funding to the office of city attorney as of July 1st.
Yes.
How does this fall in line with the cuts that are already being discussed?
We have looked at this from what our expenditures have been. We spend monies on litigation, criminal and civil, in preparing, investigating, and prosecuting. We expend those kinds of money. For example, we recently had a case where we expended $150,000 just to get it ready to file. We had to hire outside investigators to put a case together. That kind of money, we would not have to expend that kind of money to get a case ready for trial. As I said, this is a force multiplier. If you have one deputy city attorney who has the authority, and it would go through a committee and it would be managed by a grand jury coordinator, he or she would be able to issue a grand jury subpoena to a particular company or companies without the need to hire outside investigators. those documents would not have to be collected by an outside investigator who would go around, knock on doors, and do all this. It would go out to 1 or 2 locations. The documents come in, avoid that expense. Now you review it. The penalties and others that we could generate from those types of white-collar consumer cases in discussions with the Budget Committee and others, we could say, here we are. We've not only saved money on the front end, we are generating revenues in our consumer and environmental accounts, which could help offset the costs of the grand jury. As you know, this year alone, we've generated $2.4 million in consumer environmental penalties. That was one case. But that case took quite a bit of time. If we had a grand jury subpoena, it would have happened a lot quicker. So we'll be able to save and generate costs to pay for the grand jury.
And you're advocating 23 members?
That's typical. You need to have you have to have 23 so that you can have a quorum of 16, so you can get a majority of 12, typically when they vote. Sometimes the grand jury will vote on certain matters. You have to have that kind of number.
And then,
It could be less. You could have 16.
and who would select those individuals?
That would be selected through the jury system that's currently in place, through the county.
Similar to how they select for the current grand jury?
Yes. Yeah, right now, currently, people are drawn from throughout the county to sit on misdemeanor grand juries. You don't, when our prosecutors go in and try DUI cases, you could have someone that lives in the city of LA and someone who doesn't live in the city of LA on that jury. We pull from the entire county.
And the cost, would they then be compensated like the existing grand jury members?
Yes,
Same
per
kind of
day.
compensation?
Yeah, it would be a per diem, travel.
And has this been discussed with Judge McCoy or anyone from the court?
Yes.
What was his position on it?
I was not privy to that conversation. I know Mr. Trutanich had that conversation.
And what about any other members of the court, other than Judge McCoy?
Earl, do you know if he spoke to this? I don't know that. We have not encountered any opposition from the court. And Judge McCoy is chief judge of the court.
So the facility would be the court, or the facility for the hearings,
Could be anywhere. Could be a city building. We wouldn't have to pay any rent. See, since the federal grand jury sits in an office up in the 13th floor of the federal courthouse. It's not a courtroom.
And
It's
they-
a room that looks like a courtroom. It's very, very small.
and they review, and then they make a decision, and then it goes from there.
Yeah, we would not have indictment authority, but we would have authority to issue subpoenas and also hear testimony. So you would have a witness stand or something that looks like a witness stand, so they could be delivered an oath, and you would have a court reporter that would take down the statement. That could be in any room. It could be in this room.
And the dollars that would run this would come out of your existing budget?
City attorneys,
You're not asking for additional appropriation?
we are not.
And what about other jurisdictions in the state? Are there any other jurisdictions in the state that have anything similar to this?
Not misdemeanor, no. We'd be the only city. This would be a pilot project, and that's why there's a sunset on it.
And with the smaller jurisdictions that have the district attorney handling misdemeanor and felony cases, do they ever use their grand juries for misdemeanor cases
No.
in other small jurisdictions?
Not that, well, you could have a misdemeanor charge attached to a felony complaint. In other words, you could have a burglary and maybe a count 1, and then maybe a petty theft count 3 or count 2. Both could be heard by a grand jury.
So in smaller jurisdictions, they may incorporate that, but not strictly a misdemeanor type?
No, there is none. This would be the first. That's why it is a pilot project limited to the city attorney of Los Angeles. Given that we're unique, there is no dispute. City of LA is unique in the state, if not the country. We get cases that other jurisdictions would file as felonies.
And for Jerry Miller, to your knowledge, have any of the previous city attorneys ever attempted to have this type of process in place?
Not to my knowledge, no.
How long have you been around?
25 years?
Okay.
And if, Counsel, if I could add, you mentioned the authority, civil versus criminal. The city attorney is not expanding its authority. We already have the criminal authority under the charter. We are just getting another tool in which to affect our authority. We are not expanding our authority. The civil subpoena, rather the subpoena power that's under the charter now is for legislative purposes. We could not use those subpoenas for legislative purposes. The council, the committees, others, that's an entirely different kind of subpoena power. We don't want that subpoena power. Our subpoena power is different. It'd be under the charter criminal authority. So we're not asking to expand our authority under the charter. We already have the criminal authority. We're just asking the state to let us use that tool to better use our charter power.
And,
The subpoena power now is legislated by you and the others.
right.
We don't have that because we don't legislate.
Have you anticipated how many cases under the terms of this? Any idea how many would
Right
generate?
now, given the number of billboard cases we have and adulterated food cases and slumlord cases, we're going to go through those, and we could probably pick a dozen right now that we could use. As you know, we are faced with a very tenacious group of people that are constantly violating the law, and the DA won't touch those cases. They're not going to do them. Those are Muni Code violations. They're not going to do it.
So
We
would
have to do it.
would it apply to any LAMC section and all misdemeanors in the penal code or any other code which would have a misdemeanor or an infraction?
They would only apply to those that fall within the environmental, consumer, unfair trade, workplace safety, labor. For example, we have wage theft cases where people are not paying proper wages to people. The district attorney isn't going to handle those cases. Those fall to us, and then we have to get those documents that relate to the people's employment status, whether or not they are getting paid, and time sheets, time records, employment records. We have to get those. So we would file those. Those are sophisticated crimes.
And as I understand, on a grand jury, you don't have right to representation while that hearing's taking place?
No, you do. Anyone is allowed representation. Certainly any witness that receives a subpoena is entitled to representation before a grand jury.
No, before, while the hearing's taking place?
The attorney cannot be in the room.
Right.
What happens is the attorney sits outside the room, and the grand jury coordinator advises that witness. One, you have the Fifth Amendment right of self-incrimination. Two, you have a right to an attorney. Is your attorney here? You understand what's your attorney's name? You understand your attorney is outside the door? Yes. You understand that at any time you have any questions, you can go talk to your attorney? Yes. And that's what happens during the course of the grand jury. Witness will say, I have a question to my attorney. Let's stop, go
Back and
outside,
forth.
and that's what happens.
And
And
it'd be the same process with this?
Exactly the same. We would copy the Federal Department of Justice grand jury guidelines. And in fact, we've already been in discussion with Andre Barat, the currently just appointed United States Attorney, Central District of Los Angeles, and he is willing to share with us his grand jury manual.
Okay. That's all I have right now.
We have the CLA here. Can you give us your report on this bill?
Certainly. We are recommending that you oppose this legislation for several reasons. I think, first of all, I think as has been indicated, it's a state bill that would only apply to the city of Los Angeles. As a matter of course, we always recommend to the council that they oppose such legislation unless there is no other way of accomplishing what the council might want to do. The only two examples that I can think of legislation that applied specifically to the city of LA had to do with peace officer status at the airports and harbor. And it's my understanding that there was no way to accomplish that without state legislation. So the concern is, one, that it's a state law that would apply only to the city of Los Angeles. I think, similar to that would be that we believe that the policy discussion should be had by the council, and that this could be accomplished through a charter amendment. But potentially it could be accomplished with even an ordinance passed by the council, and if there were enabling legislation that needed to be had, then that could occur as well. But essentially, we believe that the policy discussion ought to be had here first, and that the people who are elected to represent the citizens of Los Angeles should have that discussion, and then pursue how to enact that rather than going the state law route. I think relative to the city charter versus state law, I think, Ms. Perry, you indicated that based on past city attorney advice, state law does not always trump the charter. It would do so if it were an issue of statewide concern. And city attorney has always advised that a charter city has a fair amount of autonomy, and that unless it was an issue of statewide concern, the charter would prevail. So again, this goes to my entire career working with the city and advice we've gotten from city attorney and the charter. So in essence, we recommend opposition. This may be a good course of action. It may be in the best interest of the citizens of Los Angeles. We simply feel that you should be having this discussion and debate and having the policy decision about which way you want to go, and then pursue the legislative remedies to get there.
So your report at this time isn't so much to the substance of the policy, but the process?
At this point, yes. I think we would need to flesh out exactly what the policy means. Discussions of where resources are focused. Again, our city attorney, elected city attorney, handles both criminal and civil. Clearly you are impacted daily by the shortage of resources and unavoidable delays. I know the city attorney's office is working very hard and resources are short. So I also think that the discussion of how resources ought to be allocated and the discussion of civil versus criminal and making sure that the services that you need are continued, that the money that you're appropriating goes for those services that you want to appropriate. Again, and I would also like to say that the charter does specifically call out who has subpoena authority. It is not all legislative in nature. The controller and the ethics commission have subpoena authority of an investigative nature, not a legislative nature. And the city attorney is not included in that charter section that calls out for subpoenas. Perhaps they should be, but I think that discussion ought to be had and made by the voters of the city rather than through state law.
If I may respond, it would be nonsensical for the CLA is comparing apples and oranges. The city attorney, if given criminal subpoena power under the charter, who would they subpoena? Would they subpoena other civil city departments? No. This power that Mr. Miller talks about, the subpoena power, is different and apart from what the city attorney's power is under the charter. We have clear power under the charter to investigate and prosecute all criminal matters within the city. We cannot investigate ourselves, though. We cannot investigate city departments. We cannot investigate city employees, as opposed to the subpoena power that is given everyone else in the city to investigate each other. Other departments and the controller issues subpoenas. It's a totally different kind of power. Every day, the legislature reviews giving us additional tools to enforce our criminal charter power. This is just another tool. It doesn't give us any more power under the charter. We already have criminal power under the charter. This gives us just another tool in which to enforce our power. We can't turn it on the city like these other subpoenas are. These other subpoenas, these folks can subpoena certain things within the city. We can't do that. This charter power is directed outward to enforce this grand jury authority is directed outward to enforce our charter authority that we already have. Just gives us another tool. We get that every day. We get sentencing authority. We can file different kinds of crimes. We can do certain types of probation. Just recently, another bill passed through, another bill that's sponsored by the city attorney's office, handled by, I can't remember which senator, just got through the Senate, which the city attorney sponsored, again, as an independent elected. What it does is it gives judges, it initially started out as a DUI case, where victims would have to go to civil court to try to get the person that damaged their cars to pay. We proposed and sponsored a bill that said at sentencing, the judge could order garnishment or other kind of restitution. Well, that bill morphed into an even better one. It said at the time of sentencing, in any kind of case where the victim was damaged, the sentencing judge could say, you defendant, you need to pay this person for your damage. That just gives us another tool. It doesn't increase our power under the charter. It just gives us another tool, just like the subpoena power gives us another tool to enforce our charter power.
Question of the CLA. The city attorney is just explaining his interpretation of the difference between power and another tool. Again, to your report, are you under the impression that this gives them expanded power, or is it relevant to just being another tool to exercise their authority that they already have?
Well, again, I suppose, since Mr. Zine was part of the charter committee, one of the commissions, I don't want to second guess what the voters of the city and the commissions did or did not do in terms of the charter and what they thought. I can tell you what the charter says and doesn't say, and there are a list of officers and boards in the city that can issue subpoenas, and the city attorney is not among them. So I don't think it would be appropriate for me to sit here and say, no, it's just another tool. It's not an extension of their power or authority. I believe it's my recommendation that be an issue that the voters determine.
And so any time the city attorney gets a new tool to enforce the criminal law, we'd have to go to the charter to get it.
Obviously not, because the legislature actually overrides that and they make those determinations and enact those statutes. Yes,
if I may, Mr. Chairman, Pete Echeverria, City Attorney's Office. The charter also provides that the city and the officers of the city can avail themselves of any other authority that is granted by state law as well. So the charter already provides a vehicle for situations such as this, where state law grants additional authority and additional powers that may be exercised by them. That's expressly included in the charter as well.
So from my vantage point as a legislator, the real question that I'm asking myself is, should this bill be enacted and become law and it become effective January 1st of 2011, is it going to interfere with all the other responsibilities and authorities and the balance of power that Ms. Perry mentioned earlier? That's the vantage point that I'm looking at this from. Whether or not this legislation, should it become law, what would it do to our ability to run this city? What would it do? Would that authority interfere with all of the other responsibilities within the city attorney's office, legislative body, mayor, controller, et cetera, all of the other electeds and all the other authorities within the city? As I see it right now, but I'm not a lawyer, I don't see the interference. However, I personally am looking at documents that are fresh. I'm still trying to wrap my mind around this and understand exactly what the ramifications are and what the actual how it would actually play out in reality. But one of the things that I would like more clarity on is the way it's been narrowed down by the recommendation and then the adoption within the bill of narrowing it down to certain kinds of activity that the grand jury could actually investigate or be convened for.
Well, the short answer, I'm sorry, did you finish?
Yeah, no, go ahead.
The short answer to your question is no. No, this would not interfere or take the city attorney away from its duties and responsibilities. In fact, it will make us more efficient. It's a force multiplier. One deputy city attorney will now have the power of 10, because what it'll do, it'll free those other people up. Right now, we have investigators and attorneys running around trying to track down documents. We actually have attorneys in these billboard cases that on their way home, they have to drive by and take photographs of some of these super graphics because we don't have enough investigators, or we can't get these companies to tell us where these super graphics are. So we get photographs. I have an investigator here, our criminal chief investigator, who goes out at night, knocks on doors, would you give me these documents? It's a waste of time and manpower to have to do that, as opposed to having a personal subpoena, a specifically surgically directed subpoena that says, provide any and all documents relating to the locations of super graphics or other unlawfully permitted signs, including any memos, telephone records, blah, blah, blah. Here you go. And you got 2 weeks to turn it over. Bring it in. Right then, I've multiplied my time and effort exponentially. And
Without
then,
having that authority, basically we're left with what you just described over the last couple of minutes.
Yeah.
People knocking on doors,
Yeah.
people asking, not requiring, but asking for information.
Begging.
And when somebody asks for information, especially when somebody perhaps might have their own personal reasons or their own agendas as to why they don't want to turn over that information most of the time does not get forwarded to the city attorney's office.
correct. So it'll be more efficient, plus it'll free up, and I can't speak for Mr. Echeverria, he runs the civil branch. Every day, bodies are leaving our criminal branch to go into the civil branch, because that's where we really have to defend the city. So, with the fewer bodies we have in criminal, this is another tool. It's only for criminal. This is another tool we can use to generate the information we need in order to, one, assess whether this is a good case. Now, we get cases that we have whistleblowers, we have other people that call in and say, this company is doing the worst thing in the world, and we have to go out and investigate this. Sometimes we have enough evidence to file. We file. Sometimes the case doesn't turn out to be that great. So we've wasted time and effort. People have to spend money to defend. Then we dismiss the case or settle it in a way that's not the way we thought it should settle. If we have this information up front, we can assess the case better. We won't waste time. We won't waste money. It's a force multiplier. And that's why it's on a short timeline. The council did the same thing with us recently with the money that it provided, the $352,000 that we're going to use for billboard enforcement. And we're going to come back in 5 months and report to the council whether we did a good job or not. And that's what we're going to be doing with this bill. We're going to be able to assess whether we did a good job or not. And if we didn't, the authority expires.
I'm going to ask Donna to come up and tell us where the bill is at and what deadlines are coming up. We'll give a bearing on
No, I want to go back to Jerry. I have one question for her, and then I'm done.
Okay. Ms. Estacio, can you give us the status as to where this bill is and what deadlines there are? Come forward. We got two gentlemen here.
Hi, Donna Estacio, Director of State Relations in the Mayor's Office. I believe this bill is on the floor of the Senate. The upcoming deadline is June 5th. That's the House of Origin bill deadline. So it has
June 5th, you said?
Yes,
That
or
would-
4th.
4th, Friday.
So it would have to get to the Assembly by then, which is the end of this week. Okay, or I guess it just passed today. They did meet today, floor session, so 23-9 out of the Senate.
Okay, so it did leave the Senate.
I just got word that it got out of the Senate just now, voted 23-9.
23 tonight. Okay, thank you. That answers my question as far as the status of the bill. So when it comes to the actual timing and urgency of this matter being deliberated by the council, the resolution by Ms. Perry, which is right now to oppose the bill, being that, as I said earlier, personally, I'm still trying to wrap my mind around what the ramifications and what the practicality and what the actual cause and effect of this bill, should it become law, would be. I would much rather put this item over for 2 weeks, not that we're ending discussion right now, Ms. Perry, but put this item over 2 weeks before I decide how I'm going to vote on this matter. But in the meantime, Ms. Perry?
Yeah, well, thanks, Mr. Chair, and I don't know if you can do this procedurally, but in the meantime, while it's being held in committee, if you could also make a referral to Budget and Finance, the Budget and Finance Committee can take a look at it, is that possible?
Sure.
Okay. I think that would be helpful to have that analysis. Mr. Carter, I just have a very simple question for you. Why can't you go through a charter amendment process?
We could.
Why did you choose not to?
We need the state law.
You actually don't. So,
Well, to go through the county,
no, through the charter amendment of the city charter, where you ask someone to sponsor a motion for you, it goes through the committee process, much like we're doing now. It's debated and discussed, and then it goes to council, and we vote on it, and then decide whether to put it on the ballot.
oh, there's two questions I see. One is why the city attorney did not go through, get council resolution and approval versus a charter amendment. Okay.
No, they're one and the same. Basically, why did the Office of the City Attorney decide to subvert the charter and go outside of the process, which they're perfectly entitled to do as individuals, but do not speak on behalf of the City of Los Angeles? It would have been probably a better approach to come to a council person, ask them to introduce the motion for you, go through this committee process like we're doing now, and then have the city council oppose or support, and then mayor affirm or deny. Then you have an official position on behalf of the city of Los Angeles that then can go to Sacramento without what we're doing now. So why did the Office of the City Attorney decide to do it this way rather than the way that I've just requested?
Well, I'll make a few comments, and I'll allow my colleague, Mr. Chavarria.
May I start off?
Well, the first thing, one quick thing, Pete, excuse me, is we believe we did not have to do that. We had a very significant number of discussions about the proposed legislation that we would be involved in this year.
Was that within the city or with Sacramento?
No, this was internally. And we had a number of ideas, and I discussed this issue internally, and the consensus was, unanimous consensus was, that the charter did not require us to do that because we were a separate elected, we were not doing this on the behalf of the city, and at no time did we ever represent that we were acting on behalf of the city or taking a position on behalf of the city of Los Angeles. That was
But you are listed on the bill as the source being the Los Angeles City Attorney's Office.
Correct.
Because you can do that as an individual. And I
Correct.
think that many legal scholars have already agreed with that, Mr. Cheriminski being one of them. But as I look at the bill analysis here, it says source, on the cover page, Los Angeles City Attorney's Office. Now, if you follow your logic, and I am trying to do that, you probably would have put the name Carmen Trutanich there instead.
I'm not
as an
aware.
individual.
I'm not aware of any recent city attorney that sought approval for a criminal legislation like this. And frankly, as we said in our
No, but what
letter-
I'm saying, I'm really asking a very simple question. It's just so simple. It's probably ridiculously simple. Maybe you've answered it already. It sounds like you had a lot of meetings in your office and everybody decided that they didn't have to go through the city charter process.
Correct.
And that's what you decided to do.
That's my answer.
Okay, okay, thank you.
There's nothing in the charter that requires us to do that.
Okay, that's fine.
Mr. Chavarria, you were going to...
If I might just add one point to that, and that is the grand jury system and process is a creature of state law. A charter amendment would not impact the county's duties and obligations with respect to that. We might then end up setting up our own grand jury system, if you will, rather than using the county's.
Thanks. Mr. Miller, what are the potential benefits of having a matter like this processed through a charter amendment?
Well, I think you get to, you get to have the policy debate about whether this direction is the direction in which the voters of the city want to go and the policymakers want to go.
What, if any, potential benefits would the city derive from developing a system of change that would separate the role of the office of the city attorney, one side being an elected city prosecutor for criminal investigation and prosecution, and the other being an appointed city attorney for civil matters, basically modeling our city attorney's office on the similar model that the county currently operates?
Well, obviously, that's something that would take, extensive analysis to look at it. Certainly at a very basic level, it would make it very easy to evaluate what's going on each side, whether appointed or elected. If it were criminal and civil, you could, again, have the policy discussion about the allocation of resources and, the role of the city attorney and the structure of the city government. You could have that discussion. The pros and cons, clearly would take a great deal of analysis, and I can't address that.
Okay. I'm going to ask you to work with me to develop a motion that we can introduce by the end of the week to take a look at that and where we begin to do the analysis. And perhaps maybe we can work with Mr. Cheraminsky, since he had some involvement in revising the charter. We'll have to take a look at how to do that. But there are a lot of good scholars out there that we would be able to use. Mr. Chairman, I think my question's been answered. The charter provides for a legislative process, and this process, for better or for worse, the city attorney's office decided that they wanted to go another way. City family, I believe, needs to work cooperatively on lobbying for legislation, and hopefully we can speak with one voice. Otherwise, we'll go back to a system that we had before the charter was changed, where everybody was approaching Sacramento and the federal government with their ideas, and the city wasn't speaking with one voice. Mr. Miller, did you want to?
Actually, if you could, and with institutional memory, I wouldn't quite characterize it as that. In fact, the part of the concern happened when the intergovernmental relations functions were split from the policy decisions. And the implementing ordinances, what it did or didn't say in the administrative code, I was there at the time. And the drafting of the ordinance and making it clear what can and cannot happen in terms of sponsoring legislation was intended to avoid exactly what we're doing here today, which is a city official sponsoring legislation with some members of the council at least concerned with or opposed in that legislation, and there isn't a discussion about where the city as a policy matter wants to go. That being said, there is nothing, of course, stopping a city attorney from advocating for legislation. But I believe that some of the disjointedness actually did occur when the charter was changed and split apart the intergovernmental relations functions.
Okay. I appreciate that. The institutional memory is extremely important. I also believe that the issues, the impact of this bill need to be discussed by the City Council and with input from all affected parties. It's my opinion that the bill subverts the charter separation of powers, and it would change the reach of one elected office without a chance for the vote of the people. I think we as a city do have the power to change our charter anytime the state takes an action to do so. We would oppose not wanting the state authority to amend our charter. I think, and I'm concerned, that the bill adds increased costs to the city budget, and I think that requires analysis. Of course, I am willing to work with the Office of the City Attorney on exploring this and other options he may want to seek through a legislative process, because it provides us with the vehicle to be transparent and to do it on the record and to allow for public analysis and public input. And for those reasons that I have just stated, and I support the committee CLA report, I'd like to see my resolution opposing SB 1168 adopted as soon as possible, and I would like this matter to be referred to Budget and Finance.
Okay. Any other questions?
Yes.
Yeah. Mr. Zine, Councilmember Zine.
For the representative from the mayor's office on legislation, does the harbor or airport pursue legislation on a federal or state level without going through council?
Not to my recollection or knowledge, no. They have been very active in the annual process that the CLA's office and our office takes in collecting legislative ideas from city departments and putting that together in the city's legislative program.
What about any other city department? The controller, the Department of Water and Power? So you're saying that every piece of legislation goes through the office that you represent?
For sponsored legislation?
For sponsored legislation. This is the first time in a long time that it's not followed that process?
From what I can remember.
From how long you been there?
2 years in the mayor's office and previously with the councilman's office. 3 years.
3 years. So in 3 years, any piece of legislation has gone through the process, through the mayor's office, to your knowledge, from any and all proprietary or other departments?
Right.
What about the police department?
No.
No what?
They go through the same process.
They go through the same process? Okay, so this is outside the ordinary process, the city attorney's office going directly to a legislator to enact some legislation?
Yes.
Okay, the process versus results. I understand from my colleague Jan Perry's comments, the process that was followed. She has concern with that process. The results, I don't know if there's going to be a debate about the results, if it's effective, and I think it would be effective if the city attorney had another tool, as it goes with any department. If they can do their job better to serve the people, I think we'd all agree that's the ultimate goal, to be more efficient, to serve the people in a more efficient fashion, cost-effective. Maybe a good course of action, that was mentioned. I think it's a good course of action. While it may not follow the traditional process, I think the course of action give the city attorney some tools to better do their job. If the police department wanted to do something to give a safer city, I don't think we'd be opposing that, but maybe we oppose the fact that they didn't follow the existing process. The method and practical aspects of this, the practical aspects is you can do your job better, quicker, simpler, and less cost to the taxpayers. The failure to comply consequences for Mr. Carter, when a grand jury would be impaneled and documents would be requested, failure to comply, what would be the consequences of a corporation that fails to comply with the subpoena? What would be the consequences of that?
It'd be contempt.
Contempt of the...
Contempt of the grand jury process.
And what's the consequences of that
Well,
into the
it could be
misdemeanor?
There's two. There could be a misdemeanor contempt. It could be a civil contempt. It's just like any other subpoena. For example, the city attorney's office issues thousands of subpoenas a month for people to appear or provide documents in civil and criminal cases. If they don't show up, then you have to go before the judge and explain to the judge why you didn't show up that day, just like a juror who doesn't show up for their duty. They could be fined.
Well, if you're requesting documents, because you're talking about environmental and other issues, and, for example, BP, let's use them for example. BP just happens to be in the news.
Yes.
And they say, you know what, we don't have time for this. We got other more important things to do. What could be the consequence on a misdemeanor? Because normally when it's a felony, obviously their state prison is a county jail or a fine, or what would be the consequences for failing to comply with the subpoena to appear before the grand jury and just disregarding not going? Is that part of the process that you'd establish?
Correct.
Consequences?
As I said, every day in criminal courts across the city, if a witness does not show up who has been properly subpoenaed and provide documentation, they are subjected to contempt of court. The judge says, I can either hold you or fine you, and that would be the same authority we would have under this grand jury authority granted under SB 1168. If someone failed to provide documentation pursuant to a lawfully served subpoena, Well, one, they could file a motion to quash it and say, we don't want to comply, we're going to fight it. We'd have to go to the duty judge, Superior Court judge, who would be assigned to grand jury matters. He or she would hear the motion and grant or not grant. If the people fail to provide the information, we would go to the duty judge and file a motion to compel to provide that information. It's no different than what they do every day across the street in the federal courthouse and the county courthouse. My experience, as I said, I was 14 years as a federal prosecutor who was in the grand jury at least 2 times a week. If someone doesn't comply, you first send the letter. Then you bring the custodian of records in and have him or her explain why they haven't complied. If that doesn't work, and it usually works 99.9% of the time, then you have to go to the duty judge, and that judge then says, turn those documents over, or challenge why you shouldn't have to turn them over. We will act no differently than all the other grand juries that operate, the thousands that operate throughout the country. And if I could add just one thing, there was some statements about whether this was unusual or not, or whether or not this has ever happened before, this process question. In our letter on Friday, May 28th, to Council Members Perry and Park, we identified Assembly Bill 1639. That was a bill that's being sponsored by the mayor, the mediated mortgage workout program. The mayor did not go before the council. The mayor did not get approval for any kind of resolution. And I just asked the representative of the mayor's office, and she admitted to me, and she can state for the record whether or not the mayor got approval for that. So what the city attorney did is no different than what other city attorneys have done and what the mayor is doing now. And I don't believe the city attorney's office should be held to a higher standard when we don't believe under the charter, we, as operating as an independent, elected, acting on behalf of the people of the state of California. When we sponsor this bill, we are acting under our charter authority to enforce the law as the people of the state of California. And that decision was made by a lot of people who are a lot smarter than me. And there was no one in that room that said, no, that you have to go to the council to get this, because we were acting in a different capacity. At no time did we say we were acting as the city of Los Angeles or the municipal corporation.
Okay, I have no problem with the process you follow. Well, it may not be the process to have all inclusion. I don't have a problem with the process because I think the ultimate goal would better serve the people of Los Angeles. So I'm not in support of continuing, I'm not in support of opposing the legislation that just passed the Senate. In fact, I favor it because I think what it's going to do is strengthen your ability to serve the people. As far as the process goes, maybe there's a lesson learned to include the council, to include the mayor's office, to go through that so everybody can be aware of it. Instead of now, I think it's awkward where the city attorney's office goes forward, requests legislation to be drafted, it's done, Senate approves it, and now the city council sends a message, we don't support this. It really makes it look rather dysfunctional when you're asking for one thing as the prosecuting agency, and we as the policymakers say we don't like what you're doing. I think that really sends a mixed message to Sacramento. I'm sure they spent time in committee. I'm sure they spent time on the vote, and now they're going to say, does LA know what they're doing when it comes to this particular issue? So I've got concern about the message we send out. Also, it's a pilot program, and maybe we could evaluate the efficiency and the impact of this before it as it sunsets, and decide if it's worthy of having a permanent program. And the other question I have, just for clarification, on the civil grand jury, why would it be impractical to have this aspect go before the civil grand jury and not impanel a separate jury?
You never want to mix civil and criminal together. I'm not aware of any situation.
Well, there is the criminal and the civil. I'm talking the existing civil. What would be the impractical aspect of that?
Of having subpoena power for civil violations?
Because when I met with the civil grand jury on 2 occasions, they looked to find more work to do, to get their teeth into something, to be more efficient, more productive.
That would be a completely different power. that would be, it would still be within the name of the people.
Well, no, I'm saying you could still do it. It's, instead of having the third grand jury, you would be able to, if it would work, since they're already being paid, there already is a facility for them, instead of impounding another group of people and the cost involved in that, why it couldn't be incorporated and folded in to what they do.
It's a different approach. The civil grand juries are more policy oriented. They focus on things that maybe the county could be doing better. And there's been challenges to those grand juries of whether or not they're truly representative of the diverse nature of the county or the city. And so our grand jury would be made up more of like the pettit jury, the types of jurors that come in and hear criminal matters. It would be very dangerous to mix the two, I think. You don't want
Okay,
to.
but it wouldn't be impossible if
We'd
that
still
was...
have to pay for it, though. We'd still have to pay for our time.
Oh, for the time that we invest?
Yes.
Okay. Anyway, just for the record, I don't go for the opposition. I think, again, it's going to send a bad message and take away a tool that you think is important to keep the city of Los Angeles on a proper level.
Thank you. Ms. Perry?
Thanks, Mr. Chair. I just want to ask Mr. Miller, Mr. Carter raised an interesting issue about the mayor and comparing the office of the city attorney to the office of the mayor. And if you could kind of respond to that in the context of what the charter affords the mayor as it is currently drafted versus what the charter affords the city attorney.
Well, the mayor, under the charter, is in charge of the intergovernmental relations function. And again, he and his staff, either in Sacramento or Washington, cannot represent that there is a city position on any legislation or can't seek support on any legislation unless the council passes a resolution. Certainly, he as an individual, again, can advocate for legislation. But it's really the same issue.
I'm sorry, it's really a what issue?
It's really the same issue with city attorney, that in order for the city to officially be taking a position on legislation, the council has to adopt a resolution. Now, in terms of sponsorship, there is no doubt that city officials have sought to sponsor legislation in the past. To my knowledge, none of that legislation has ever directly impacted the city, and whether or not the council chose to express its concern in those instances, is really a moot point at this point. But there is a process. Mr. Cardenas solicited proposals from all departments so that we would look coordinated and we wouldn't look foolish, as Mr. Zine indicated, so that we do have our act together. And I believe in protecting the council interests. That is the process that should be followed. I don't believe that city officials should be sponsoring legislation as in their official capacity as city official without coming to the council.
Okay, thank you. And thank you, Mr. Chair, for allowing me make a few last points. And again, to me, this is about process. And there is a process and a pathway to achieve this. This has been a very interesting discussion, although it was never my intent to get into the weeds on the merit of this proposal, because I don't think the merit, whether it is a good thing or a bad thing, is why I asked this to come to this committee to examine. The purpose of my examination and the purpose of my asking my colleagues to oppose Senate Bill 1168 has been because of the process issues that have been raised by the pathway the office of the city attorney has taken. And so I would ask that my colleagues give consideration to my position and oppose SB 1168. And I do appreciate your consideration in allowing this to be reviewed by the Committee of Budget and Finance in the meantime before it comes back again to this committee.
Mm-hmm. Okay, thank you, Ms. Perry. We do have one public comment card. I'd like to bring Marcia Sells. Marcia Sells filled out a public comment card. Thank you. Gentlemen, thank you. You have 2 minutes, Ms. Sells.
Thank you very much. Just for introductions, I'm a past president of the Holmby Hills Homeowners Association. I sit on the Bel Air Beverly Crest Neighborhood Council, and I'm founder of the Coalition of Homeowner Associations for Council District 5. But I'm speaking for myself today. In my opinion, especially after listening to all these very good questions and the good discussion, a charter amendment is really unnecessary and would take a significant amount of the people's time and money. The people of Los Angeles voted City Attorney Carmen Trutanich into office by a considerable margin. The voters spoke loudly and clearly. The voters trusted Mr. Trutanich's judgment. We, the people, provided full public input at that time. We are tired of political barriers to effective government. I understand Mr. Cherminsky's protecting his work of art. We understand that no other city attorney has formally requested what is being requested now. They didn't prosecute billboard violators either. We understand that. But SB 1168 will provide greater operational efficiencies because I have read Mr. Cedillo's information, I've read Ms. Perry's information, the legislative analyst's information, and Mr. Trutanich's information. That this measure needs public vetting is not necessary. Grand juries are an established tool which have been used effectively by other legal offices in the state and county. I hope you will work to save the people of Los Angeles time and money and withdraw this resolution, oppose this resolution, and be supportive of SB 1168. The argument for a charter amendment only appears to this person as a smokescreen against more effective government. Thank you very much.
Thank you, Ms. Sells. Anybody else here for public comment on item number 2? Public comment on item number 2 is currently open. Seeing no one else come forward, it's now closed. With that, public comment on item number 2 is over. And at this time, the committee will basically ask the City Council President if he would like to refer this over to the Budget Committee for their analysis. And at the same time, we will be hearing this in this committee, if not at the subsequent meeting of this committee, which will be 2 weeks from now, a month from now, depending on what kind of timeline the Budget Committee is able to hear this matter.
Okay.
I got a technical question. When is this expected to go to the Assembly?
It'll be in the Assembly, probably won't be disposed in the Assembly for the next few months, so we do have time. It just got out of the Senate, and it made that deadline. But it's not likely that this will be disposed of within the Assembly over the next few months. So we do have some time. 30 days, we certainly have 30 days before this, we see actions culminating in the Assembly. One question of the City Attorney's Office. Did I miss the question or request, or is there one at all? Is it the City Attorney's intent that he gain support from the City Council?
Yes.
Or he's agnostic about us supporting it or not? Because right now, the only thing before us is an opposition.
Well, what I'm hearing now is that the objection is not to the substance of the legislation, but rather it's a process internal to the city. If the city attorney's office made a mistake, we apologize. A lot of minds looked at this before we went forward on it. None of them believed that the charter applied to what we were doing, but rather we were doing what is typical fashion for an elected. If it's a process question, then we're more than happy to provide additional information and actually submit. We've drafted a resolution that would ask the council for support. If it's a process question, now that we have time, we've gotten through the Senate, we can have this vetted, we can talk to the council and say, do you support this? It sounds to me that everyone's in agreement that this is a good idea.
I wouldn't say that.
Well, it sounded like, I apologize if I misspoke, but it sounded like it boiled down to process rather than substance. And if it's a process question, we can resolve the process by drafting a resolution that addresses those process questions, because we do not want to have the city look dysfunctional. If people believe that this is a legitimate, substantively good, cost-effective measure, we can have that discussion.
Mr. Chair, I just like to just clarify for Mr. Carter so it's very clear, and I only speak for myself. When I make a decision on how to vote, I try to gather as much information as possible so that I can analyze how to develop my own position. I do that in reliance on information from the Chief Legislative Analyst, Chief Administrative Office, and when applicable from the Office of the City Attorney, and from experts in the field whenever, necessary. I have not made a decision on whether or not your proposal or the legislation the city attorney proposed in Sacramento is a good piece of legislation or a bad piece of legislation. The process of introducing a charter amendment, whether a person likes that or not, affords us as elected officials the opportunity to go through that analysis. So what I'm concerned about is the fact that we do not have an analysis on record. I don't think it's a good idea to do it retroactively, and certainly should be done by objective, disinterested parties like the CAO and the CLA to be able to provide that kind of advice to council members. And to the lady who spoke on your behalf, ma'am, you seem like a decent person, and I appreciate the fact that you come down. And as for your reference to a smoke screen, I'm not sure what that smoke screen would be, but I know it's a popular thing right now to allude to that with respect to people who are in public office, but I can assure you there's no smoke screen here. It's pretty straightforward. It's pretty simple. And I don't see why we can't go through a process of public discussion on the record. That's what transparency is. It's really not that complex. But again, I haven't made a decision on whether your proposal is a good one or a bad one. I don't know. And I think we had an interesting discussion here. Mr. Zine's a police officer, so he, has a lot of background in grand juries and things like that. But I, for one, I think would be highly beneficial not only to the public, but to people like me and perhaps other colleagues who do not have that kind of experience to understand what the ramifications are of this, and more than that, what the cost ramifications are. I think we owe that to the taxpayers to be able to do that. And that's why I believe a charter amendment, while maybe not required, and you can introduce legislation as an individual, would have been a preferable route. It actually would have been good for you, too, because it would allow you to build consensus not only internally but externally. And there's no need for an apology. I'm certainly not seeking one. My ego's not that big. I don't need it. I'm just merely asking questions on the record and documenting the record so that at some point as we move forward, if we ultimately go through committee process, budget and finance, come back here, go forward to council, that we have a very well documented record for anyone who cares to and wishes to examine. I think the sad part about our political process here in the city now is it's highly polarized. If you don't agree with someone, you're their enemy, and you certainly dare not ask a question that is grounded in anything substantive or has any sort of intellectual analysis associated with it. And for me, sorry, but I was trained in critical discourse, and that is how my mind functions, and I'm going to continue to do that. And whether I win or lose, and whether I prevail on opposing SB 1168, it's not really the point. The point is that I raise these issues of process, and whether people wish to embrace them or not is certainly their decision. And for my colleagues, they reflect that decision in the way that they cast their vote.
Thank you. Okay, no more comments.
I'm ready to cast my vote.
Thank you very much. Okay, as committee action has been
We're
taken.
not voting today.
We voting?
No, we're not voting. It's coming back.
No, no, we're coming back. I'm still going to read this stuff.
Hello?
Uh, Item number 1.
You said cast.
Item number 1 is a report from the CAO relative to the 2009-10 third construction projects report. This item has also been referred to the Budget and Finance Committee.
Good afternoon. My name is Alma Gibson with the CAO's office. Our office is submitting to you our third construction projects report for this fiscal year. The recommendations in this report consist mainly, again, of funding adjustments related to the city's construction projects. And these funding adjustments are needed in order to keep the projects on track. These financial adjustments consist primarily of reimbursements to various city departments from either general obligation bonds, from the Capital Improvement Expenditure Program, NICLA financings, and the Prop O Clean Water Bond Program. Of the total $194.5 million recommended in transfers and appropriations in this report, a total of $178.4 million is recommended to provide expenditure authority to provide expenditure authority from the previous council-approved set-asides within the Prop O program budget to continue the implementation of various projects. These projects are the Machado Lake Phase 1, Wilmington Drain Multi-Use Project. The total set-aside approved is $15.7 million. The Machado Lake Ecosystem Rehabilitation Project, the total set-aside approved is $89.4 million. The Echo Park Lake Rehabilitation Project, which is a total of $73.3 million. Approximately $7.3 million is for staff cost reimbursements for work on the Propo Clean Water Bond Program for this fiscal year. And positions for these programs have been authorized for resolution, and funding is for services provided by staff that may include program, project, and construction management, project control, and property acquisition. And in addition, approximately $3.3 million is recommended from Propo funds to the South LA Wetlands Park project to front State Prop 50, which is the Integrated Regional Water Management Plant grant funds. These grant funds will be used to incorporate water quality scope elements into the wetlands park. Finally, approximately $4.8 million is recommended for appropriations to GSD. And this is to perform construction work on various construction projects. And these are projects to, for example, the police stations. And this is to do post-construction work at the PAB, for example, work at the fire station, such as asbestos abatement, at Fire Station 42 and 96, street service yards, asbestos abatement at the Clark's, the Central LA Recycling Transfer Station, Cahuenga Pass Yard, and also to do improvements at the asphalt plant number 1, and also work at the recreation and park projects such as the Harvard Skate Park, Venice Recreation Center, and also to do work for the CRA projects, and that the work consists of asset management and construction and building maintenance work. We now have representatives for the projects listed in this report if you have additional questions pertaining to these.
I got a simple question. Are we in budget on time?
Yes, if we get this approved by council before June 18th.
If we do it by June 18th, we're on schedule?
Yeah.
On budget, on schedule?
Yes.
Okay, great. That's all I need to know.
Thank you.
That's it? Oh.
Thank you.
All right. Thank you very much.
Okay.
Anybody here to make public comment on item number 1? Public comment on item number 1. Seeing and hearing no one come forward. Public comment on item number 1 is now closed. With that, is the recommendation of this committee that we approve this item. This item is approved unanimously. Thank you. We now move to item number 3.
Item number 3 is a report from the CLA and a resolution relative to the city's position to support AB 2677 Fuentes, which would increase allowable surcharge cities and counties can ask voters to place on the sale of aerosol cans and permanent markers pursuant to resolution Weezer Parks.
John Wickham with the Office of the Chief Legislative Analyst. AB 2677 would allow the city to place a surcharge on the sale of aerosol cans and permanent markers of up to 25 cents. Funds generated from this tax may only be used for graffiti cleanup, prevention, and educational activities. Our report does recommend support for this bill. However, we've learned that the bill has died in committee. It did not even make it out of the policy committee in the House of Origin. We can move forward with the recommendation to support this bill. We could move forward to adopt a position to support this matter in any other bill that comes forward, or you could choose to receive and file a report.
A lot of things were stricken out of this bill before it died, but
Yeah.
in the last version of the bill, it allowed up to 25 cents per marker or aerosol can?
Yes.
Okay. Seems like 25 cents per marker can get a little steep, especially since some of these materials are being used by schools and teachers and a lot of legitimate reasons. Aerosol cans are a little bit more expensive item. 25 cents per aerosol container is probably a relevant amount per container. So being that this died, I'm going to pay more attention to it the next time it gets revived. However, in the last version of the bill, was there restrictions and/or requirements as to what that money could be used for locally?
Yes, it would only be used for the graffiti abatement.
Okay. So basically, this is an opportunity for local government to have a usage fee based on the materials that tend to cause, when misused, tend to cause that problem, and therefore utilize those fees to work on abating the problem.
Exactly.
All right. Sound like a pretty decent bill, a little heavy on the marker fee, but like I said, I'll be getting more involved in this bill next time. So the bill has died, so I guess we could receive and file this at the moment.
I just want to say that the funding for graffiti removal has been reduced, and this money would be put to good use by continuing our graffiti removal programs throughout the city of Los Angeles. And I thought that maybe 25 cents appropriate for a marker. I think the spraying can should be $1 to give us sufficient money, since the graffiti causes so much blight to the communities of Los Angeles. So if it comes back, I would make a recommendation that if you want to keep it at 25 cents for marker and $1 per can for spray paint, to give us additional dollars, since citywide all those funds are being reduced for eradication, and it's going to hurt the city in the long run by not having that graffiti removed.
Yeah, and also, as I get more involved in this bill, what I'm going to be looking at is to whether or not we can actually include funding for locally for arts. That's been cut drastically as well.
All been cut.
And that's another thing. Well, with all due respect, you've been an officer for many years, Dennis, and you know that idle minds end up getting into mischief. And if we had more constructive places and things for our children to do, we probably would have less reason for Dennis to chase them down an alley and go get them when they cut them.
I could chase them.
You radio the guy radio the guy to cut him off at the end of the alley.
These are gone.
But you get the picture.
As long as we got a helicopter, you can't get away.
Okay, so the recommendation would be to receive and file. Do we have anybody here for public comment on item number 3? Or on item number 3, anybody here for public comment? Seeing and hearing none, public comment on item number 3 is now closed. So with that, the action of this committee is to receive and file item number 3. Thank you. Item number 4.
And item 4 is a CLA report and a resolution relative to the city's position to support continued funding for the Energy Efficiency and Conservation Block Grant pursuant to Resolution Parks Perry.
John Wickham with the Chief Legislative Analyst again. The city received $37 million under the Federal Energy Efficiency and Conservation Block Grant Program. This is one-time funding approved in the federal stimulus package in February 2009. The resolution here seeks administrative or legislative action that would actually create additional funding in future years to ensure that these programs can be sustained into the future. And our recommendation is to support the resolution.
Move that item.
Okay. And this, we're talking about some of the ERA funding?
Yes, this was through the federal stimulus program, the ERA program.
Okay. All right. Well, one of the things that we need to make sure that we keep in mind is that we monitor how these funds are expended. And as you mentioned, sustainability of these programs is obviously something that's very important. And when the funding goes away, it obviously makes it much more difficult for us to sustain the programs. But most importantly, whatever monies we get, whether it's state or federal money, we need to make sure that we have strong monitoring systems as to how we're handling that money and if we're complying with the law.
Absolutely.
All right. Any questions?
No.
No? Okay. So with that, anybody here on item number 4 for public comment? We're on public comment for item number 4. Seeing and hearing none, public comment is now closed. With that, its recommendation is to approve the CLA report and support continued funding for the energy efficiency and conservation block grants. Okay, that's unanimous. We approve that. Now we move to item number 5.
And item number 5 is a report from the CAO relative to an amendment with RD Systems, Inc. and the Department of General Services for security services.
Diana Mangiolu, Office of the CAO. The report before you recommends extending the contract between General Services on RD Systems. The contractor basically provides services for security access and control systems. So the extension, the amendment would be for the extension of time, allowing the contract to be extended through February 2011. Total citywide expenditures allowable for the contract is approximately $7.5 million, but the amendment wouldn't be adding any additional funds to the contract. A total of 28 city departments receive security services, and the contract would be administered by the Office of Public Safety within General Services. And Office of the CAO recommends amending the agreement.
Okay. Any questions? Any questions?
I got just a couple of questions. What type of security checks are done on the employees?
Security checks on the employees was the question?
The employees from the system?
We conduct background checks on the contract employees who are assigned to install and conduct maintenance at city facilities.
What have we found in those background checks? What have we found in those background checks?
We have found that most of them are in compliance with standard civilian background standards. In one instance, there was an individual that was not in compliance, and that individual, the company was told not to assign that individual to any city sites.
What was his issue, without giving his name?
It was drug use related.
Drugs?
Yes.
Do they maintain the security at police facilities also?
They do some work at police facilities, yes.
Okay, because obviously, if we don't do background checks and they have access to police facilities, that could be a problem.
Correct.
The other question is, why can't some of this work be done by IT, since they're involved in that type of process? I mean,
Just cut them another 158 bodies.
well, if you're spending $5.7 million, $7.5 million total contract, if we could maybe keep some city employees employed by having them do some of that work that were given to a private contractor.
As of right now, we don't have any ITA employees who possess this specific type of expertise. We actually have our security responsibilities bifurcated between the two organizations. They handle alarms and panic buttons. This particular contractor, in coordination with the Office of Public Safety, handles closed-circuit television, digital video recording, and access control.
And then the request for 10% reduction, they have a $7.5 million contract. They want to give back $3,750. That's not very generous.
The reduction that they presented to us was 3% off of materials, which for the remainder of the fiscal year was estimated at $3,750. That figure has risen since then to between $5,000 and $10,000.
Okay,
And for next fiscal year will be even greater.
Because I believe that if you look at the open market right now, most prices are coming down on everything. And I know that talking to builders and suppliers, their costs for products are going down because of the economic situation. So I would think that they should get closer to 10% versus the few dollars they're given under a $7.5 million contract. And I know they're the only game in town. It just troubles me that when we're laying off city employees, we go to a private contractor, they're not willing to give more than that, and I'm sure business is going to be tough for everybody, but I'm concerned about city employees that are going to lose their jobs.
That function is already built into the contract, so when there is a reduction in the cost of, in this case, products, that discount is given, and this discount is on top of that price reduction.
Okay.
So the overall initial discount prior to the counteroffer was 12%. With the counteroffer, it's now 17% off of whatever the lowest price available is.
Okay. Because obviously we can keep people working for the city that don't have to get laid off. The more money we can save.
Right.
It's just a matter of dollars and cents. Okay.
And from the labor standpoint, the contractor over the 5-year term of the contract has not taken the opportunity to, with the built-in 2% increase annually in the cost of the contract while prevailing wage has gone up. So it's actually been a continual scale of savings to the city as every year goes by.
Even though prevailing wage has gone up?
Yes.
Except for city employees and council members.
They're on prevailing wage.
Don't start.
Staff. One more thing regarding security. If you, the doors into City Hall from the council members' parking area, those doors are supposed to be alarmed and secured, and they're not. You can just walk right through them.
Okay, we'll take a look at
The
those.
back doors at City Hall that,
Exactly.
well, you know, it's on public record. Maybe they can fix it because I've reported it before. It still hasn't been fixed. But they're the back doors that the public has access to when they go to the VIP parking. Those aren't working.
We'll take a look at that.
Okay, and it's R&D system that put them in.
Okay.
That's on public record.
Yeah, let's make sure we secure those doors and double check all the other functions it's supposed to be secured. Thank you very much. See no more questions from the committee. Is there anybody here for public comment on item number 5? Public comment on item number 5 is now open. See no one come forward. Public comment on item number 5 is now closed. With that, as a recommendation of this committee that we approve the item, this item is approved unanimous. Okay, that concludes all the items on the agenda. Therefore, is there anybody here for general public comment? They're all gone. General public comment is open on this committee. Is there anybody here for general public comment? Seeing and hearing no one come forward, general public comment is now closed. This committee is now adjourned.